introduce one of our awesome attorneys from the Pompano Beach, Broward County office. Hopefully if you haven't had the pleasure of one of Emily's classes before, you're in for a treat, because she takes this stuff and really does a great job of keeping your interest. So without further ado, Emily, please take it away. Tell us a little bit more about yourself, and let's get started with the class.
Thanks, Jeff. Hi guys. So I already sound weird. Sorry about that. I'm a little under the weather. You might hear some coughing. You might hear some sneezing. Sorry about that. Well, I have a throat lozenge in, and we'll try and power through and see if I can hold out for an hour without, having a coughing fit. So
If you start having a coughing fit, I've got my dad jokes ready.
Okay. You're on standby here. So I'm Emily, as Jeff said. I've been with the firm, I think it's going on 12 years now. I'm one of the partners here. I've been practicing for 18 years. That just sounds like so long, and I still feel like I'm only 25. But here we are. So, all right, today we're doing the fair housing, assistance animals, all that fun stuff. We'll jump in. It's just meant to be sort of, a educational course, not giving any specific legal guidance. As Jeff said, you can get the slides at the end. Obviously, if you're a client of ours, reach out if you have any specific questions. Obviously, we're always here to help. If you're not a client of ours and you'd like to be, you can always reach out, and same thing, we'll be here to help you. But let's dive in and we'll get started here. And we're here for about an hour. I think we advertised a few extra minutes so we can go over any questions, but we'll try and keep it to about that time. So people, if you have a hot lunch date, I don't want to keep you. Let's see. Mine specifically will probably be soup, about, my hot lunch date. All right. So let's start. Federal Fair Housing Act, assistance, animal, or pet. And we title it that for a specific reason. You're going to hear us talk about assistance animals, pets, and they are two different things. So keep that in mind, guys. Those are going to be two different things that we're talking about. When you say you have pet restrictions, different than your assistance animal issues. So, all right, let's dive in. First things first here. So basically, as we should all know at this point in time, our country, within the constitutional limits, we want to be able to provide fair housing to everyone. Department of Justice, the Department of Housing and Urban Development, which is referred to as HUD. You'll hear us say HUD all the time. That's who's basically going to be responsible for enforcing the Fair Housing Act. And there's the Federal Fair Housing Act, and then there's some other things, but basically Fair Housing Act, well, for our purposes here and with these slides, we're just going to call it the FHA, or you may hear me just say Fair Housing Act. That's what we're going to be talking about. So it's essentially HUD is the agency that we're going to be talking about, and our restrictions and our policies, so to speak, are through the Fair Housing Act. So Fair Housing Act, what is it? How does it work? All that good stuff. All right. Basically, it's what it sounds like. Fair Housing Act was created to provide fair housing. So it prohibits discrimination when we're talking about housing on the basis of, and then there's the protected categories, all protected by basically our Constitution: race, color, religion, sex, national origin, familial status, which gets tricky. That has to do with age, that has to do with pregnancy. And then our last one here is disability. That's what we're really going to be talking about today. That's the category, that's the protected class that really has to do with our topic today, is disability. Now, we also tell you to look at your state and local ordinances too. So the federal restrictions, or the federal protected classes, are the ones we just listed. But then there are also local state ordinances that would protect additional groups. So for example, in Palm Beach, they've also added some additional categories: sexual orientation, age is specifically listed, marital status, gender identity or expression. Those are also covered under Broward County, and then Broward County has some additional ones as well. I think political party or political affiliation is one of the Broward County classes or categories. So there are different ones depending on which county you're in and where you are. So those are protected categories. Those are the things that we can't be discriminating based on. We can't be making decisions based on someone's race, someone's color, someone's religion, all of those things. And like I said, those categories may seem very obvious to you. The big one that you're going to potentially get, sort of confused about is disability. And that's the one that we're here to talk about today. So US Code or the CFR. US Code, and this is a little background, a little legal, jargon for you guys, but we'll give you a little history here. The US Code is basically the statutes enacted by Congress. Certain laws essentially say that then the administrative groups or the governmental agencies can then basically supplement the code with their own rules and regulations. The CFR is the Code of Federal Regulations. That has the rules and regulations that are adopted by the governmental agencies. Bottom line, for our purposes, these are the rules and regulations and the code and all of that we're enforcing, basically. And that's the legal basis for not being able to discriminate. All right, so rules and regulations adopted by the FFHA. So this is in Title 24 of the CFR under the category that establishes HUD, Housing and Urban Development. These are their rules, essentially. So that's the chapter. These are the parts. If you wanted to look this up and really sort of look at the actual law and read through the statutes or the rules here, this is a section we're talking about. This also could get into, this covers some of the housing for older persons legal basis, but we're not getting into that too much today. The big one, like we said, is the discrimination because of a handicap, discriminatory housing practices. That's the stuff we're going to be talking about today. So, Fair Housing Act prohibitions. All right. So bottom line, Fair Housing Act prohibits housing providers from discriminating against any applicants or residents because of their disability or disability of anyone associated with them. So maybe your applicant is, the wife, but the husband is actually would have the disability or whatever it is. Or, the tenant, the lease, the person on the lease is one resident, but the other occupant is the one with the disability. It applies in both cases. So the applicant or a resident who has a disability. FHA prohibits treating persons with disabilities less favorably than others. So basically they have to be treated, the same. There has to be an equal opportunity to use the home. So it makes it unlawful for any person to refuse to permit, at the expense of the disabled person, reasonable modifications of existing premises occupied or to be occupied by such person, if those are necessary to afford that person full enjoyment of the premises. So reasonable modifications, it's a little different. We're going to be talking about two things. So reasonable modifications is one. The next line here is it's unlawful for any person to refuse to make reasonable accommodations in rules, policies, practices, when those are necessary to afford that person an equal opportunity to use and enjoy a dwelling. So two different things. Reasonable modifications, that's usually a little more straightforward when we talk about, maybe an owner uses a wheelchair and they're asking you, hey, board of my condominium association, can I put in a ramp right here because I need it for my wheelchair? That would be a reasonable modification. A reasonable accommodation is basically making an exception to a rule or to a policy. So that's something where if you have a no pet policy, that's what we're going to be talking about today. So you would be making an exception if this was a disabled person who made a request for a reasonable accommodation to allow them to have their dog in the building or whatever it may be. So two different but related things. A reasonable modification, that basically changes, usually sort of is a physical change almost, versus a reasonable accommodation, which has to do with a change or an exception to a rule or a policy. And again, these have to be allowed when the person is disabled so that they can have an equal opportunity to use the dwelling and full enjoyment of the dwelling and all of those good things. We won't get into the exceptions here or exemptions here. There are some things that may pop out at you that we can touch on, some of the exemptions. FHA, when we talk about familial status, I know we mentioned it a little bit before. If any of you guys are in a 55 or over, a 55 or better community, there's questions there about, again, what about discriminating against familial, when familial status is being protected? What about, discriminating against families and children and all of that? There's a difference there because there's a specific exception for a 55 and over community. So you wouldn't run into that same issue. That's allowed, essentially. It's almost like you're legally allowed to be discriminating based on age because it is a 55 and over community. That's the one that comes up the most often. This is a picture of my coworker and her dog, or her son and their dog, because, we do like animals here. I want to be clear about that. I know we sort of come off a little, sometimes a little bitter and a little jaded when this topic comes up, only because it's very frustrating when we see how this gets abused. But we are animal people. We do like animals, but we also like rules and we like people to follow them. So, all right. We'll touch into ADA and fair housing FHA comparisons. You'll hear all the time, people will say to you, hey, you have to allow me to bring my dog because ADA regulations say so, or whatever it is. Or it's an ADA issue. You can't ask me questions about my disability, blah, blah, blah. Okay. So there's, again, they overlap, but the ADA and the Fair Housing Act are different things. The ADA prohibits discrimination based on disability, similar to Fair Housing Act, which also covers disability, but covers some other things. But the ADA applies to basically public places, public spaces, public accommodations. It could apply to an association if that association is open to the public, if maybe they hold events there, maybe there's, they have events at the clubhouse that are open to the public, not just their owners. Could be something that applies. And the only animals covered under the ADA are service dogs, which require specific particular training. So ADA requirements, for the most part, are not what we're talking about today. We're talking about fair housing, which again, they sort of overlap, but they are different things. So, excuse me. So fair housing, it applies to essentially all of our associations. So we represent, and I don't know if we made this clear before, but our law firm, essentially, all we do is community association law. So most of our clients are the condominiums, the HOAs, the co-ops, occasionally the developers, occasionally individual owners, but for the most part, our clients are the associations. So for our purposes, that's who has to worry about the Fair Housing Act, are these associations and our boards. And our board of directors have to be aware that the Fair Housing Act is something that they have to comply with, and they have to make sure that they're, paying attention to. So again, ADA, for the most part, you don't have to worry about if you're on a board, but Fair Housing Act, you do. And again, they sort of overlap because you're still providing that you can't discriminate based on disability. All right. So the two terms that the two different, I'm sorry, guys. The two different terms are handicapped in the FHA world, and the ADA says disability. Essentially, those two terms are exactly the same. So, so don't worry about sort of if you use the right word. Essentially, they have the same legal meaning. For whatever reason, I don't know why we don't just use one, but here we are. So handicap means a person who has a physical or mental impairment which substantially limits one or more major life activities. There's a record of that impairment, or they're being regarded as having such impairment. It doesn't include use or addiction to a controlled substance. Now, when we break that down, what's a physical or mental impairment? And I won't read this to you verbatim, but essentially you can look into this. It is a pretty broad definition. So a physical impairment most people, can think of right off the bat, oh, if you were blind, that's a physical impairment. No problem. That's the easiest example. And you'll hear me talk about a seeing eye dog and that sort of thing today, because that's again, the most straightforward example of an assistance animal. But also it includes a mental impairment. So you could have something that's not so, physically obvious. It could be a mental impairment that has to do with a speech issue, autism, epilepsy. They go through this whole list of things. It could be something just as sort of simple and straightforward as anxiety, depression, things like that. Sometimes there's a physical mental impairment sort of combination where maybe you have a cognitive issue, maybe you have seizures, and you need an animal to alert you when the seizure is going to start, something like that. And that's a case that we've had where a board was unsure. They had a tenant applicant who said they needed a dog because they had a seizure disorder. On their, initial meeting, the tenant seemed perfectly fine. There didn't seem to be any physical indications of any sort of disability, seemed to function normally. Came into the management office to check in or do something, drop something off, and had the animal with them. And the board was a little hesitant. The board wasn't sure if this was sort of another case of maybe, an exaggeration, so to speak. And the tenant had submitted a note from a doctor and the whole thing, and was sitting there, and all of a sudden, and the property manager said to me, now this really changed my mind, because I'm sitting there and the dog starts barking and is barking at me and is barking at this applicant. And all of a sudden, then immediately the applicant knew and said, oh, I'm about to have a seizure. Call 911. And literally the manager, 2 seconds later, the person sort of had their seizure and they were able to call 911. Everything was okay. But the property manager said that really changed my mindset on this whole thing, because if you had seen the person, you would never have known. So interesting the way sort of these different things can work out. All right, major life activities. So that means functions like caring for yourself, performing tasks, walking, seeing, hearing, speaking, breathing, learning, all of those things that you need to do to basically function. So, and then having a record of such an impairment essentially means what it sounds like, that you have a history of it, you've been classified as having that disability, regarded as having the impairment. So again, you're treated by another person, all of that good stuff. So that's the definition of, sorry. So now when we're talking about a disability, the question then becomes, so what are we allowed to ask? So here are some things you can't ask. It's unlawful for an association to ask if an applicant for a dwelling has a disability. So if someone comes in and says to you, hey, I'm thinking about buying a unit in here, or I'm thinking about renting a unit in here. Don't say, nice to meet you, do you have a disability? Don't start off with that. If they're intending to reside in the dwelling, you can't ask them if anyone associated with them has a disability, or the nature or severity of the person's disability. So again, couldn't ask, hey, oh, you're not disabled, what about anyone else who'd be moving in with you? And how severe is that disability? Not things you're going to be able to ask. Reasonable accommodations versus reasonable modifications. Now, we said there's a little bit of a difference, even though they're a similar idea. Reasonable accommodation under the FFHA is a change or an exception, adjustment to a rule or a policy or a practice, something like that. A reasonable modification is more of a physical change, a structural change made to the premise. So like I said, maybe a ramp being installed, versus the reasonable accommodation would be what we're talking about here, allowing an assistance animal when you're a no pet building. A person with a disability could need both, could need either, depending on what the disability is and what makes sense for what they're, what they need. It's unlawful for any person to refuse to make the reasonable accommodation if it's necessary to afford that handicapped person the equal opportunity to use and enjoy their dwelling. An assistance animal is essentially a reasonable accommodation. That's what it is. It's a reasonable accommodation to your pet restriction. So a disabled person has to be allowed to have that assistance animal because that's how they function in the space. That's how they're going to be able to have an equal opportunity to use the unit, use the home, whatever it is, use the common elements, because they are disabled and they need that animal. So that's a reasonable accommodation. If you have a pet restriction that, or a pet prohibition, where you may say we're a no pet building, we're a no dog building, or you can only have one dog and it can only be up to whatever 15 pounds because we don't want big dogs in our building. Well, someone may have an assistance animal that's a 30-pound whatever, 30-pound pit bull. You could say, well, we don't allow pit bulls. Well, might be a problem. You might have to allow it. And we'll get into some of those details in a minute. So now how does this all work? What's the process here? So the FFHA does not require that you adopt a formal procedure for any of these requests. However, we suggest, and we think it is better, that you have a procedure in place, that maybe you have a package with a request form and some rules set up and that sort of thing, so that if someone comes to your management office, or if you have an applicant, someone shows up in the building, it's a tenant who's moved in, and they say, oh, by the way, I have my assistance animal, I just want to make sure that's going to be okay. You can respond and say, yep, here's the package, please fill this out, please get us the documentation, and we'll take a look and we'll review it, and then we'll confirm that the animal is permitted or whatever it is. Now, then you can look through what they've submitted to you. Now, keep in mind, even though we tell you it is good to have this package in place and have a form for the applicant to fill out, you can't force them to follow that. So essentially, you can't say, oh, well, you didn't fill out our form, so we're not approving your request, and the dog has to go. If an applicant comes to you and says, hey, Mr. President, I have an assistance animal, I just want to make sure it's approved. Here's a letter from my doctor. Can you, here's the documentation you need. Here's the supporting information. Let me know what else I need, and make sure we sign off on everything, and I do everything I need to do. So you may get a request that way. It could be that casual, that informal. It could be somebody comes to the management office, they shoot you an email maybe that just says, hey, here's a note from my doctor, or maybe it doesn't even include anything. It just says, I have an assistance animal, please confirm, but my request is approved, or please confirm I can have my assistance animal. So you may have to go back and say, well, we need a little bit more information, we need some documentation, something like that. But you can't say, you didn't fill out our form, or you didn't fill out our packet, so we're not going to approve it. That's not going to be allowed. But you could have that packet because it's a good idea to have it. So now they don't automatically get a reasonable accommodation just because they're disabled. They have to request it. And like I said, it doesn't have to be done in any particular manner or in any particular time frame. It could be when the person moves in. It could be before they move in. They could let you know in advance that, hey, I'm moving in and I have this assistance animal. Or it could be 6 months down the road and you never realized, and all of a sudden they say, oh yeah, you guys just noticed I have this dog, it's an assistance animal. What do I need to do to, fill out your paperwork, make my request? And it could be something as simple as, if you're in an HOA and you just notice your neighbor walking a dog one day, and you said, wait a minute, you moved in and you didn't say anything about an animal, and actually we don't allow pets here. That person then may respond to you, oh, it's my assistance animal. Okay. So now you can inquire further. So you're making a request, for an exception basically to our pet policy. Now, how can we document that, or how can we support that and review it and all of that good stuff? And it could be a family member, could be somebody else who makes the request. Maybe it's maybe it's the wife's dog, but the husband filled out all the paperwork, whatever, that's fine. Maybe it's a tenant's, again, request. but the owner is actually, the owner slash landlord is the one in communications and sending you guys the paperwork. That's fine too. They don't have to use magic words. They don't have to say, hey, I would like a reasonable accommodation. You just have to know that basically that's what they're doing, that they're making a request. They understand there's a restriction and they basically want to be allowed to have an exception to that restriction, or a change or an adjustment. Again, maybe there's something where it's not a strict prohibition, but maybe it's sort of a modification to a rule, something like that. And like I said, it could be done even after that resident has brought the animal into the community. So you can't say, you know, hey, but you didn't ask for this dog. You didn't ask for your reasonable accommodation first, and the dog's now been here and it can't be here until it's approved or whatever. They can do it after the dog's already moved in, and you still have to treat it the same way and look at the request in the same way. So when we say assistance animal, that's sort of the overarching broad term. For a reasonable accommodation, you have to ask, the association really should know what kind of assistance animal we're talking about. So is it a service animal or is it a support animal? Now, those sort of get intermixed and jumbled a little bit, but they are different. So ADA defines a service animal, and that has a narrow definition: any dog that's individually trained to do work or perform tasks for the benefit of a person with a disability. Work or tasks essentially means that they are trained to do a specific action and assist with the disability. Again, the clearest, cleanest, easiest example is the seeing eye dog that, you know, leads a blind person. They are trained to assist that person who has a disability. Other animals are not going to be considered service animals under the ADA. And the work or the tasks performed by that animal has to be related to that person's disability. So there has to be a connection there between what the animal can do and what the disability is, and how they work together. Now, emotional support, comfort, you hear comfort animal a lot, companionship, that's not work or tasks for the purpose of being a service animal. So if it is an emotional support animal, if it is a comfort animal, that's not a service animal. That's a support animal. That's an assistance animal, but it's not a service animal. They are actually different categories. So how do we figure out if it's a service animal? Start, number one, is it a dog? If the answer is no, not a service animal, move right along to the next category. If the answer is yes, could be. Is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? So again, readily apparent. So obvious. You can tell just by looking at the animal that it is trained to do something. Yes. So let's say yes. So then now further inquiries: unnecessary, inappropriate, stop basically right there. It's a service animal. You don't need to know anything else. So the most obvious one, like we said, is a seeing eye dog, guiding an individual who's blind, pulling a wheelchair, something like that. If you see the animal doing that, and it is obvious, it is open and obvious and readily apparent, then it's a service animal. We don't need to go any further. There you go. So the big thing is going to be, is it readily apparent? So can you tell just from looking sort of what's going on, what that dog is doing, how it's helping the person, what the disability is? If that is open and obvious, readily apparent, that's it. It's service animal. All right. Next question. Is it required because of a disability? So again, if the answer is no, then again, not a service animal, maybe something else. If it's yes, then you should be granting the request unless it's unreasonable, and we'll sort of get into that. So if the, well, we'll get into it. All right. So the other category, like I said, if it's not a service animal, it's a support animal. If it is, and now support animals are also under this umbrella, and you may have to allow them as well. And you probably will have to allow them as long as, again, you have the support that you need. So a support animal is a trained or untrained animal, does not have to actually be specifically trained, does not have to have any sort of certificate. That's a common misconception. Doesn't need to have a a little license or a badge or a wear a vest or any of that. It could still be an animal that you're going to have to allow. Sorry. So they do work, they perform tasks, they provide assistance, or they provide emotional support. So that's the other sort of that's the big category that we see more often around here. Support animals don't have to be dogs. They could be another animal that's commonly kept in a household. Cats are usually the one we see, sometimes birds. For the most part, someone will say, I can't live without my cat. It brings me comfort, whatever, something like that. If it's a sort of a more exotic animal, not commonly kept in households, that could apply as well, but we'll get into that. All right, so establishing the disability. Does the person have an observable disability, or does the association have the information giving them reason to think this person is disabled? So again, easiest example, most straightforward example is a seeing eye dog with a blind person. Generally, you can tell from just looking at the person and looking at the animal that this person has a disability, that the animal is helping, all of those types of things. Other disabilities, you're not going to necessarily know just by looking at the person. Like I said, the example with the person who had seizures. That property manager tells me she had no idea that this person had any sort of health concern, any disability, would never have known, other than the fact that then she happened to witness the dog start barking and happened to witness the person say, I'm going to have a seizure, and then the person had a seizure. So they may have some sort of disability that you cannot see and you wouldn't know about. And that's not enough to say, well, I can't see it, so it's not real. Not how this is going to work, guys. So then the question is, all right, do you have information that essentially gives you reason to think they're disabled? So did they submit some sort of doctor's note? Do you have information that would lead you to think they're disabled? So if they're requesting this accommodation, did they provide you information that reasonably supports that they have a disability? If yes, all right, then we're going to move on. If no, then you don't have to grant the accommodation, but it may be a case where you need to get more information. You need to look into it a little bit further. As a general rule, I wouldn't say your knee-jerk reaction should not be no whenever you get one of these requests. Don't come from a place of no. If you have any inkling that there's a request coming, or that it's or that a request has been made, sort of think of it as, okay, we're going to review this. All right, we need to look into it. Don't start with no. Don't sort of knee-jerk reaction. Nope, we're a no pet building, can't have your animal here. Nope, can't, that's not going to be enough. You didn't submit enough documentation. We don't have the information we need. No, get rid of Fluffy. Don't approach it from that angle. That's not going to work out well for you guys. So, sort of have the mindset of, we're going to look into this. We want to review it. We want to get the information. We want to see if this is a reasonable accommodation that we need to approve. All right. So establishing the disability. Now, if someone's going to demonstrate that they're disabled, they have to give you something, unless it's something as obvious, like we said, as the blind person with the dog. For the most part, that's not what we're dealing with here. We're dealing with a disability that you can't see, that you don't know about, that they're going to have to give you the documentation to prove, basically. So it can be done in a couple different ways.
One of the questions that comes up quite a bit is, can an association ask for more than one proof? What does it have to be? Can they only do one doctor? Can they say, hey, we need it from two doctors? Or
no, good question. So that's always the question, is essentially, what's going to be enough? What do we need? And it's hard because we don't sort of have a hard and fast rule for these things. They can establish a disability in a couple different ways. The most likely way that you're going to learn about it is they're going to submit something to you from some sort of health professional. So typically a doctor, not always, sometimes it's a nurse practitioner, sometimes it's a physician's assistant, Sometimes it's maybe a social worker or a therapist if it's a mental health type issue. So you really have to look at it on a case-by-case basis and look at what's been submitted. And then also it should make sense. You shouldn't be getting, a letter from a podiatrist that says, oh, my patient has depression and needs a cat. That sort of doesn't make sense. You know what I mean? So that might be a case where we would say, wait a minute, why did you submit something from a podiatrist about a mental health disability? So you need to look at it and sort of look at it on a case-by-case basis. What we touched on before is, just because they print out a certificate online that says my animal is an assistance animal, that alone is not going to be enough. So just, sending you that certificate and saying, oh, look, the internet says Fluffy is a certified, whatever, emotional support animal, whatever they come up with. That's not enough. You need something from a healthcare professional. And then another thing to keep in mind is I think it was now 2 years ago, but again, since COVID, I have no concept of time anymore. They did change the statute a little bit to specify if it's an emotional support animal that we're talking about, if it's a request for an assistance animal that is for emotional support. And now we like telemed. Telemed's great. It's nice that you don't have to go to, you don't physically have to go into an office every now and again. But if it's going to be a letter from a telemed doctor, that person either has to be licensed in Florida, or if they're not licensed in Florida, they have to confirm that they have seen the patient at least once in person. Now, it does happen. We live in sort of a, obviously a snowbird transient state, especially in South Florida here, where we do have owners that buy a second home that come down from maybe New York, Boston, Canada even. And they may have a doctor up there. And so their letter is from a doctor up there. That makes perfect sense. But it was really meant to cut down on the people who just find a random internet, service that'll just fill out a paperwork for them. So we do have that extra little sort of security. If it's an out-of-state licensed, again, healthcare professional, they're going to have to confirm that they've seen that patient in person at least once. Otherwise, it has to be a Florida licensed professional. So that's a nice little, again, it doesn't do much, but it helps a little bit on cutting down on some of that sort of fraud that we've seen. So as we said, a lot of these disabilities that do impose a substantial limitation on a major life activity and would result in basically as being established or being confirmed as disabled, all of these things here can cover a bunch of stuff, stuff that you don't think about necessarily. Deaf, blind, those are sort of our obvious ones, like we said, but maybe it's a post-traumatic stress disorder, traumatic brain injury, those types of things. Now the question is, all right, we've established the person's disabled. So we've checked off sort of number one, and it affects their major life, functions. Now the next part is, okay, so do they have a need for the animal? Because again, there has to be a nexus here, disability and the animal and how they sort of work together. So we say, so the question is going to be, does the information they've provided indicate that that animal does work or performs any tasks or again, even provides them emotional support that essentially helps with their disability? If the answer is no, then again, we're sort of done here. The two things don't go together. So granting the request doesn't make sense because technically you haven't demonstrated that the animal and that the animal helps with the disability. So, but now again, we would look at it as a whole. If the answer is yes, then we have to look at the type of animal, and odds are this is going to be something you're going to have to approve. So is the person disabled and it substantially affects their major life functions? If that's yes, then the question is, does the animal assist them with those things? Do those things connect? If that answer is yes, now we move on to sort of the next category. Now, we already talked about this a little bit. What documentation can you ask for? So usually it's going to be a letter or a prescription or something, and maybe it's an affidavit. It doesn't have to be an affidavit, but something from some sort of healthcare professional. Doesn't always have to be a doctor. Could be, like I said, a therapist, a nurse practitioner. Going to depend on what the disability is, going to depend on what they're asking, all of those things. You want to look at all of this on a case-by-case basis and talk to your attorneys to make sure that what you're being provided is enough, and that, you know, you need to support or to approve the request. If it is, and the big thing here is too, if it's a non-observable disability and it's an emotional support, you know, request, like we said, then you can basically ask them to have you can ask for sort of some additional documentation, sort of some additional clarification. If it's something that's obvious, if it's something, like we said, it's a blind person, it's very clearly, you know, disabled, and the animal helps them and guides them, then you're not going to go down this road. You're not going to ask for all this documentation. So it's really going to depend on what we're talking about here. Internet documentation, we touched on this a little bit. Those certificates, those, you know, little badges, whatever it is, that's not going to be, by itself, that's not going to be enough. HUD has clarified that for us, which was very nice. It could help. It could sort of be part of the package that they submit to you, but in and of itself, if they just say, you know, hey, I've printed off Fluffy is an emotional support animal certified by the Emotional Support Animals of America.com, that alone doesn't mean anything. All right. Oh, official records. This is important to know too. So any of these documents that you get, and when you're, you know, going through this process and getting this request from an applicant and reviewing it, and they're submitting paperwork to you, and maybe you do have a package, like we said, maybe they fill out the you know, all the information you ask for, they submit a letter from their doctor, whatever it may be. Keep all of that information. That is all part of the official records. But if you're condo HOA, keep in mind that any medical records that you have and anything that has to do with the approval of a lease or sale, and then any social security numbers, driver's license numbers, or any like personal identifying information, all of that, even though it's part of your official records, is not open for inspection. So if you have a letter from, you know, Dr. Jones in support of Mr. Smith's request to have, you know, Fluffy in the building, make sure that letter from Dr. Jones is in your records, but not going to be open for inspection. You don't want an owner to come in and say, oh, wait a minute, I saw this letter from Dr. Jones. I didn't know Mr. Smith has, you know, post-traumatic stress disorder, and it seems like he could snap at any moment. You know, you don't want to open up that door. And also you run into this issue where the statute says those are not open for inspection. And you could see where, like I said, that could get very messy. So now we're looking at the type of animal. Is this an animal that's commonly kept in a household, like a dog, a cat, a bird? Grant the request. Once we've gotten our documentation, we've established it's a disability and the animal helps, good to go. If not, you are probably still required, well, maybe required, may not be required to grant the accommodation. Keep in mind here, the request is for a reasonable accommodation. So reasonable actually does have a meaning here. So if you had, you know, somebody who said to you, I have an emotional support tiger. Well, that's not reasonable to ask a condominium building to have a tiger being kept there. That's it. So that's sort of where we're looking at it from that lens. It's not reasonable, but we do have some cases where you might have a sort of a unique animal and you might have to approve it. The example here, what if you had a monkey that is trained to perform certain tasks? It actually can get a bottle of water, unscrew the top, put in a straw, all that stuff, hand it back to a person who has maybe a spinal cord injury. In that case, that even though, you know, you might say, well, can't you, I don't know, couldn't you have a dog or a cat or whatever? Well, here they need a monkey because the monkey has hands and can be trained to open that water bottle. A dog's not going to be able to open a water bottle for you. So that's something that, even though it's sort of a strange animal to have in possibly a condominium, it would still make sense. It would still be a reasonable accommodation in that particular case. a lot of what you're taking away from this, hopefully, is that, all of these should be looked at on a case-by-case basis, what the request is, what the disability is, all of those things. The other thing to look at is, the animal poses a direct threat. So like I said, it wouldn't make sense to say, I have an emotional support tiger that I want to keep in my condo. I mean, that's the crazy example, but there's a reason we make those examples. It could be something as simple as, a direct threat where we're talking about a specific animal. So maybe, and now this does not mean breeds. We don't want to sort of, paint that picture with a broad stroke here. You can't say, well, it's a pit bull and pit bulls are dangerous, so they can't have a pit bull in our building. Well, and this may come as a surprise to everybody, if it's a reasonable accommodation, the size of the animal is not going to matter. Essentially, if you have a size restriction, you may have to make an exception. If you have a breed restriction and you think, dangerous breeds are not allowed in your building, you may still have to make an exception. Pit bulls aren't naturally just, off the list just because they're pit bulls. You could still have an emotional support pit bull. You could still have a service animal that is a pit bull. If it's an animal that has a history, a specific animal that is a direct threat or something like that, or and this could be a case where maybe, the tenant has this pit bull or maybe it's not even a pit bull. Maybe it's just, maybe it's a golden retriever, but for whatever reason, this golden retriever seems very dangerous. It has growled at everybody. It lunges at people. The owner has a hard time keeping it on the leash. It bit someone's shirt, whatever it may be. If there's a reason to think that specific animal, so maybe you had this tenant here for a couple months, then they actually submitted their paperwork, and now you've had, reason to think that animal it's not reasonable for us to allow that animal to be here because that animal is actually dangerous. So not just because it's a pit bull, we're saying no, it has to be that animal. You have a history with that specific animal. You already know, it's documented, that particular animal is dangerous. Now, again, you could be able to still sort of work around that. Maybe the animal has to be muzzled. Maybe you still could allow the animal to stay in the community. You'd have to sort of see. But that's the type of thing you're talking about, the specific animal, not just it's dangerous because it's a pit bull. Interactive process, like I said before, you're coming at it from this whole thing. When you get a request, when anyone mentions having one of these animals, do not, like I said before, don't come at it from a place of no. And I know that sounds like a weird sort of therapy phrase, but that's really the best way to think about it. You're not going to be able to deny a request just because you're uncertain if that person really has the disability, if they really have the disability related need for the animal. You can't just say no right off the bat. You have to engage in an interactive process. That's what HUD wants to see. If you do end up with a challenge with some sort of discrimination claim, you want to be able to say, we were trying to get more information. We were trying to figure out, we didn't know what the disability was. It wasn't obvious to us. And the tenant, we asked the tenant for some documentation to support their request. You want to engage in this interactive process, give them a chance to get you the documentation. Don't just say, hey, get us a doctor's note by Friday or get the dog out of here. Be careful of what you're doing and make sure you're really engaging in this interactive process. If it's refused, you have to then look at some alternative accommodations. So sometimes sometimes again, it's maybe not a reasonable accommodation, but something else would make more sense. Good things to be aware of that sometimes you sort of run into these traps. You can't require these applicants or the residents to pay a deposit for these animals or an extra fee for these animals, even if you charge a deposit for a pet, or you charge an application for a pet, or whatever additional fee you would charge for a pet. Because if you remember, we're circling back to the very beginning, an assistance animal and a pet are not the same things. A pet is one thing, an assistance animal is something else. So you cannot treat them the same way you would a pet. So you can't say, hey, we require a pet deposit or a security deposit or an application fee or whatever it is, so pay us the same amount. No, an assistance animal is looked at differently. You can't require that they pay fees for it. Not a pet, two different things. You can't ask them to provide access to their medical records. You're not getting into the weeds with what their disability is, or their whole, treatment background, or their whole medical history. You're not doing that. You're just getting proof that there is a disability from, some reliable source, basically some health professional that says Mr. Jones has a disability. But that's it. You're not saying, well, how many times have you treated him? For how long has he been a patient of yours? When did the disability start? But you're not getting into any of that. So keep in mind, you can't sort of go down that road. The other thing to keep in mind that you cannot do, or you're going to run into an issue, don't unreasonably delay your response. Don't put it off. And essentially by doing that, now you've constructively denied the request. And that could be treated as an improper denial. And then you could be on the wrong side of a discrimination claim again. Then we run into this question, where can the assistance animals go? Now, sort of the ballpark rule here is the animals, if this is a properly documented assistance animal, that assistance animal is allowed to go anywhere the person is allowed to go. Okay? Now I get it. People say, well, wait a minute, but that doesn't seem right. How come the dog gets to come to, the card room or whatever? Think of all of these animals as seeing eye dogs. When you're thinking about it, and I know in everyone's mind, there's a little bit of a difference from an emotional support animal from a seeing eye dog. I get it. I understand that, but think of them as the same in your minds. You have to start thinking of them as the same. It's the only way to sort of make it all make sense. They have to be able to go wherever the people can go, unless it causes an undue financial burden or something like that. Or, they don't necessarily have to go in the kitchen when you're having a gathering.
I'm going to give you a hot tea break for a second. Just want to remind everybody that we had the Q&A turned off. I'm going to activate the Q&A now. So if your questions, keep them general, because we don't understand or know we understand them, but we don't know your documents. We don't have them in front of us. So please keep your questions general in nature as to the statutes themselves, the laws themselves. And also keep in mind too, that the information you're hearing today should not at all be considered as legal advice. This is all informational as it pertains to the course. So be sure to seek your association counsel. And if you don't have one, I know of a pretty darn good one. So Emily, back to you. And we have about, about 15, 20 minutes left in the advertised time.
Thanks, Jeff. We'll wrap it up and we'll leave some time for questions. So a couple things we already touched on a little bit. Basically, like I said, those restrictions that are going to apply to pets, can't apply them to your assistance animals because, again, those are different things. So if you have a weight restriction, a breed restriction, size restriction on your pets, doesn't apply to your assistance animals. And again, think of it like a seeing eye dog. If you had a weight restriction of 20 pounds and someone has a 100-pound seeing eye dog, you would never tell them they couldn't have that dog in the building. So just think of it that way. The board can promulgate additional rules about these animals. Be careful. Talk to your attorney before you do that. There are some sort of landmines you might want to be aware of. Some things that might apply to support animals, not service animals, things like that. Also be aware that an assistance animal doesn't count toward the number of pets. So similarly, like we said, it doesn't apply because they're separate things when we're talking about weight, breed, and all those restrictions. It doesn't apply if you're talking about the number of animals either. So if you're a building, maybe you're not a no pet building, maybe you're a building that says we allow everyone to have one dog. Well, you can have your one dog, but then your assistance animal you can also have. So you would really be able to have two animals potentially in that case. Violations of the Fair Housing Act. So essentially, this is what you don't want to run into. You don't want to run into a discrimination claim. You don't want to run into somebody saying you have violated, you board, you association have violated the Fair Housing Act because you're discriminating against me because I'm disabled and you're not allowing me to have my reasonable accommodation, whatever it is. So different ways that can come through: intentional discrimination, disparate impact, and failure to allow the reasonable accommodation or modification. We won't go through sort of the technical things here of how you bring a complaint. HUD administrative hearings. This is all in here if you want to go through the process. Bottom line, again, you may be on the wrong side and someone may, make a claim against you if you don't treat these requests properly, if you don't review them, and if you don't allow for a reasonable accommodation when you have the supporting documentation for it. There's a bunch of cases here that we talk about. You can read through this at your own leisure here. We don't need to get into these. It's good to know sort of how the courts look at how these cases work. There are a couple where the bottom line was the association came out on top because the association didn't have the information it needed, didn't have any documentation. The person who made the request didn't provide. This one actually is this one here. They asked, the board asked the gentleman twice to provide documentation and he didn't do it. So basically they felt they couldn't approve his request because they didn't have the information they needed. So here, when they denied the request, the court held the association didn't act improperly because they had requested the additional information. That one was favorable to the association here. A lot of these turn into cases where the board really overstepped what they were doing. But there's good ones to look through. All right. We have a couple scenarios. Maybe we want to touch on them a little bit. That are good little exercises for everyone to look at here. We'll give a little hypothetical. An applicant has an obvious mobility impairment. They regularly use a walker to move around. They ask the association to assign them a parking space near the entrance to the building instead of the space that's located in the parking lot further away. Can the association require the applicant to provide additional information about their disability? And can they require the applicant to provide additional information requiring the need for the requested accommodation? So in this case, and this is this hypothetical here, this is a good one to sort of keep in mind too, because again, we've made it pretty clear here. It's an obvious mobility impairment. So you don't need to know more about the disability, and you don't need to know more about sort of what the nexus is here with the request, because it all makes sense. You obviously see they have a mobility impairment. It is obvious that they would like to have a space closer because they have a mobility issue. So can you require additional information? No, not in this case. Let's see. So this one, and then this is a little twist on this. So a rental applicant who uses a wheelchair advises that they want to keep an assistance animal in their unit, even though it's a no pet building. Okay, so the disability is apparent, the person's in a wheelchair, but the need for the assistance animal is not obvious to the provider. So then the question is, can they ask the applicant to provide information about the disability related need for the dog? In that case, yes, because, okay, the person's in a wheelchair, but we don't know how it's clear they're disabled. So that was sort of like we said, box number 1 is checked. But box number 2 is, but how does the animal, tie together with that disability? How does the animal help them? If we can't tell that from here, this isn't a case where it's not a seeing eye dog. Then we need to get more information and ask them what the connection is, how the dog is related. So that would be something where, yes, you could ask for more information. All right. This one should be nice and easy. Let's say because of a disability, an applicant with a hearing impairment needs to keep an assistance animal in his unit as a reasonable accommodation. Can the association charge an application fee? Can the association charge a security deposit? No, we went over this. Don't charge fees that you would charge for pets because there's an assistance animal, because pets and assistance animals are different things. I see Jeff put the link in there. Do we have any other questions I should go through while we're going through these hypotheticals, Jeff?
I've got a bunch. I actually turned off the Q&A again because we already had 32 of them, and there was no way if it continued, we'd get to all of them, and I doubt we'll get to all of them as it is. So I pasted them onto a blank document. I can share that screen, or I can
you want to share that, and I'll just hit a couple of them while we have a few more minutes.
You got it.
There's a couple other sort of hypotheticals here in the slides, guys, that you can read through and quiz yourself on.
So here's the first page. There's a lot. I notice a lot of people are asking, for instance, like Peggy, wherever the person goes includes all pool and spa areas. I guess when it comes to assistance animals and ESAs.
So this is another thing. Again, it depends if we're talking about a support animal, an assistance animal, what we're talking about. I would talk to your attorney about that when we're talking about the pool. Can they be in the pool area? Probably. Now, can they be in the pool? Probably not, unless, again, there's a reason that that animal needs to be in the pool with that person. Because again, there's sort of health concerns with having an animal in the pool. But you might have to allow them in the pool area.
Yeah.
I know that's a tricky one because everyone, and listen, guys, I hear it every day, all day, where we hear people say, but they go to work all day. They're allowed to, they leave their animal when they go to work from 9 to 5. They go on vacation. They don't take, Fluffy with them on vacation. So why does the animal have to go with them everywhere on site, so to speak? And I know, but that's just what's allowed. And sometimes, we look at it in terms of a lot of sort of these fake fraudulent requests, but you have to treat each one like it's a legitimate request.
Yeah. And, we're not doctors, you or I, nor
Right.
are we therapists. And there are different, I go to therapy there. I said it, and I have different triggers that cause different types of anxiety. And, and for me, for instance, while I don't have an ESA, sitting here working takes my mind off everything else, and I have no stresses right now, so it's different for everybody.
Yeah. Do we have do you have that sheet, or am I?
Are you seeing it? I'm sharing it on the screen
No,
now.
I don't see it.
I'll read you a few.
My share.
I took over your share, and so you should be
wait,
seeing
hold on.
mine right about now.
Maybe I have to.
No. All right, let me stop the share, and I'll read you a few questions here. This is interesting. You covered about whether if somebody's out of state, a snowbird, that kind of a thing. But if someone has a photocopy of a provider letter from another state, can we, meaning I guess the manager or the board, ask for an original?
A photocopy of a photocopy of a photo.
I guess it's the same. A photocopy is a photocopy, whether it's
Right.
an original or not. And so I don't.
I mean, is there, and again, sort of all of this is depending on the context and all of that. Do you have reason to think this person is, that this is complete nonsense?
Right.
Or, do you think this person forged that signature? I mean, realistically, you sort of have to, again, look at it all.
Well, let me follow. This question by somebody else is totally related. Can a manager call a doctor to confirm if they indeed issued a specific letter that they have in their hands?
No, I would not do that. No.
Okay. I didn't think so. And that kind of answers the question really about the copy. If you have the copy and it's a legit practice, what's the difference?
Again,
I don't want to, if I live somewhere else, I don't want to
Right.
travel with my original with the fear of losing it.
Right. And it might be that, again, that letter doesn't have enough information, and maybe you have to go back to the owner and say, or to the applicant and say, hey, we need a little more clarification. Can you get something else from this provider? And then you would have a sort of a second letter to compare it to, or something like that. Because again, a lot of times now there's this internet sort of, flurry in the last couple of years where people just fill out paperwork or fill out a form online, hit, pay $79.99, and they think they're good to go. Now, keep in mind too, that what changed in the last couple of years, and there's been legislation proposed for years to try and crack down on this and stop sort of these false reports, these false claims of, assistance animals when they're not. But ultimately, we don't seem to get the legislation we want. So there was a little bit of something. Now there's technically, if you falsify information on these certificates or these letters, or claiming that someone's an emotional or something's an emotional support animal when it's not, technically now the Florida statute says that falsified information, you could be subject to a second-degree misdemeanor. So there's something out there that sort of maybe will scare people into not submitting these fake requests, but we all know realistically there are a lot of fake requests, and just, if you know it in your heart, that's not necessarily enough to deny it.
Yeah.
Have to look at each one like they're legitimate and review them and properly.
Yeah. Just like the law, innocent until proven guilty.
Yeah.
Here's an interesting one. Our HOA application. Now, notice this person uses the word application, not condo docs or covenant. Our HOA application clearly states that no animals are allowed. The prospective buyer signs a statement that says he or she does not have, or they does not have an animal. After being approved and they have moved in, they show up a month later with a dog that they have apparently owned for 10 years. Can we reject their request because they lied on their application? And this is after they're moving in. So like, what do you do?
Oh yeah, that happens all the time. So again, that's where you need to look at sort of the whole picture, because depends on what the application really says. If it says, we're a no pet community, please confirm you don't have a pet.
Yeah.
Well, if that person's going to claim that this is an assistance animal, it's not a pet. So technically they didn't lie in the application.
Yeah.
If you wrote, do you have an animal? And they said no, again, that's a little bit more on the gray zone, so to speak, but you should still treat it like a regular request. Okay, we see you have an animal. Please give us a support for your request for a reasonable accommodation. Do you have a, again, letter from a provider or something? And then take it from there. You can't just say, well, based on that, we're going to deny it. You have to look at everything. So then if they get sort of a dicey printout from the internet and you make another request, this isn't enough, then maybe, and they don't submit anything else, then you might be at a point where you can say, no, this animal needs to go.
You have time for a couple more before I do
Sure.
the housekeeping one more? I think I've solved the sharing. Are you able to see my screen now?
Oh, now I see it.
So this is still page one.
Can we require a license from animal control? Well, I'm going to tweak that question a little bit. So we said you can have rules and regulations. One of them basically could be, and this ties into, can you require up-to-date shots? Yes. So you can require that those animals are properly licensed, properly registered with the county, whatever, certain counties require licenses, certain ones don't, that they're up to date on their shots, all of that stuff. So you can make sure that at least the animal is, properly vaccinated and all of that. That's still, you can still require that. Even if you had that for pets, you could have that rule for service animals, assistance animals, anything, all of those as well. So
yeah. Next page.
And then what if a previously approved animal becomes dangerous at a later time because could the approval be rescinded? That's another interesting one. So we've had that come up where, the person submitted the proper documentation, they had a disability, they had the animals helps them, animal is approved. Then later, once they move in, the animal seems to become dangerous, whatever it may be, lunging at people, growling at people, just seems to be a nuisance. Also, nuisance comes up if the animal barks all the time and, that sort of thing. If there's a problem with the animal down the road, you then still should sort of work with the owner to try and get the problem fixed. If it's something where, again, the owner agrees to put the animal on a muzzle, put the animal on a harness so that it doesn't pull on the leash or something like that. If you can make sort of adjustments that make sense, cool. If you can't, if you tried that and really nothing's working and this animal has now, gotten off the leash and attacked somebody or, chased a little boy on a bicycle through the parking lot and the kid was terrified, if you have documentation that this animal really has become dangerous, it might get to a point where you can tell the owner the animal has to go. But try to sort of do everything you can until you get to that point.
Yeah.
Let's see. Oh yeah, tenant left the unit for a 1-week vacation, left the dog behind. What does the association do? Now, I don't know what that means, left the dog behind.
Yeah, like unattended. I'm
right,
guessing
just by itself in the unit? That doesn't seem okay. But
I'm thinking what you mentioned is that what you touched upon earlier, like how come you don't have the pet with you when the ESA with you when you go on a vacation or when you go to work? This might fall into that category.
Yeah, that's my guess. Maybe, left it with another resident or someone's coming to check on it. That's still fine. You're allowed to do that. You're allowed to go on vacation. You're allowed to go to work. You don't have to have the animal with you all the time just to prove that it is your emotional support animal.
Yeah.
So,
tell me to scroll if you need me to.
All Are you required to provide a dog park that allows the dogs to run? No, but there should be some area that you can designate for walking the dog, for allowing the dog to relieve itself. There, it gets a little interesting where, if we're talking about cleaning up after the animal, generally that's one of the rules. We say you have to clean up after the animal. But basically, you know, again, if it's a seeing eye dog, I don't know that person really can clean up after the animal. So again, there might be a change if we're talking about sort of a service animal versus an assistance animal, that kind of thing. We have to look at it more, you know, in more detail and what the actual issue is.
Yeah.
Someone said, can a single resident have more than one ESA? That's a good question. Oh, Robert Ash. Hey, Robert. Yes, you can. If there's a demonstration that you need both animals, basically. So, you know, just a letter from a doctor that says Mr. Jones is, you know, has anxiety and I prescribe an emotional support animal. Probably not going to be enough for Mr. Jones to show up with, you know, 2 dogs and say, well, look, I have a letter that says I need an emotional support animal. You would need something that actually says that he needs both animals, or that he need, you know, whatever it is, specifically he needs those 2 animals. And we've seen that where maybe a letter from a doctor said, well, those 2 animals are, you know, brothers and they can't be separated. And so they need to keep those 2 together, and that person needs those 2 animals for whatever reason. Or, you know, that maybe the wife needs Fluffy and the husband needs Spot as their emotional, they each have an emotional support animal. That could be 2, but you would need sort of the documentation to demonstrate why you need both.
I'm getting rid of this because you addressed
Yeah.
this one already about certain sicknesses and diseases and stuff like, so that's going to get rid of that.
Yeah.
one.
So they would have to demonstrate sort of how the animal connects there.
There's a really good one here. Not that all the questions are great, but this one in particular about short-term rentals. Does the same thing apply? So I guess this is assuming your association allows short-term rentals, and then being that so let's assume they do allow it. Is this person allowed to advertise his or her Airbnb as pet allowance or ESA allowance, or do they have to allow an ESA as if they live there?
Right. So that's essentially what it is. You have to allow the ESA as if the person lives there. So, I mean, they shouldn't be advertising it as, you know, hey, pets are allowed as long as you say it's an ESA. We don't want that. But ultimately, right, the same way if you had a guest, if you had a tenant, if you had even a short-term tenant, that person has to be able to use the property, have an equal opportunity to use the property. So if they show up, you can't say, well, tenants aren't allowed to have ESAs, only owners. That's not going to fly. And a short-term rental, same thing. And now maybe it doesn't really make sense because maybe that short-term rental is only there for a weekend. And by the time you even notice that they had a dog, they're already gone. But in theory, they should have given you the documentation to essentially approve that request to allow the dog to be there.
And
I mean, couldn't be allowed in the kitchen. So essentially, it's sort of the concern with where the animals can go have to do with health, safety, sanitation issues. So, like I said, you wouldn't walk the animal through, you know, the restaurant at the, you know, in the kitchen of the restaurant at your clubhouse or whatever. We might have health, sanitation issues there. Oh, does the animal need to be under physical control, a leash? That's another one that we would say, put that in your rules, that the animal has to be essentially, yes, under some sort of control. So most times a leash or, you know, maybe a harness, something like that. Again, there might be an exception, maybe for some sort of service animal, perhaps, but for the most part, you should be able to require that the animal is under the you know, sort of applicant's control when going through the common elements, when walking through the lobby, when, you know, walking through the hallways. They can't just allow the animal to roam freely and run, you know, run through the property just because it's an ESA. Again, there could be a question if it's some sort of service animal, a seeing eye dog, but typically those are they're still on, you know, sort of a harness. You can't require that they carry the animal. That's another one we've run into where people say, well, you have to carry your emotional support animal through the lobby. No, that's not. Again, keep in mind when we're talking about assistance animals, it's a bigger umbrella and you really want to think about even that seeing eye dog. So you would never require a blind person to carry a 100-pound, golden retriever through your lobby. So that shouldn't be the rule. That wouldn't make sense. But it could be under, the person's control, on a leash, on a tether, on a harness, something like that. That rule would work. Yeah.
Last couple.
We allow ESAs with a properly approved application. Are we forced to allow visitors to come onto the property? What does that mean?
I'm guessing if they have a guest coming into an announced guest to come in and I'm visiting Joe Schmo and the guest has an ESA.
So again, it's a little tricky when we're talking about guests, but generally, yes. If you are a no pet building or no pet community and someone keeps showing up with a dog, even if they don't live there, you can then notify the owner or the tenant or whoever this person is visiting. Hey, your guest keeps bringing a dog here and we're a no pet building. What's going on? And give them the opportunity. Oh, that's my buddy has an emotional support animal. Here's the information, so you can document your file. Let's see.
This is interesting. Is it one and done? Like
okay. So this is
or?
interesting. That's a good question, because this has been sort of a subject of debate too.
Mhm.
Can you require the owner or the applicant to provide annual confirmation from the medical provider that the disability continues or whether it's been treated? Here's the thing, that's tricky. So
Yeah.
I would not put in your rules that every year they're going to have to basically renew it and give you a new letter. No. But if there's a reason to think that the condition has changed, an actual reason to think the condition has changed, then perhaps you can ask for a follow-up. We typically put in our packet or put in the rules that if the condition does change, they are supposed to inform you. So if it was, and this could be something, the clearest example is, it was an emotional support animal for my husband, and my husband passed away, and everyone in the building knows he passed away. And now the dog is still here and this dog is still with me. Well, now odds are I would probably get a letter that says, now it's my emotional support animal because it reminds me of my husband and all of that. And I'm severely depressed and all that. But still, you may want to go through the motions. There have been ones too, where the animal was trained to do something for maybe some sort of physical disability, or, the person was in a wheelchair and all of a sudden now they've recovered and they're not in a wheelchair anymore.
Yeah.
So, and you would know that, but from seeing them. So that could be something where you'd say, well, wait a minute, do you still need that animal? How does that work? Your disability appears to have changed. But again, it may not have. Just because they were in the wheelchair doesn't mean the animal actually was helping them with any mobility. It could be the animal was an emotional support animal, right, and that hasn't changed. So a lot of sort of tricky things to keep in mind there.
Okay. Well, hey, we
made it.
I'm so sorry, guys. Pretty close to
coughing and sneezing and blowing my nose.
No, it was just hope you feel better. Thanks for pushing through it. I'm sure everybody appreciates it. Emily, one more time, if you can muster up the vocal force there before you start coughing again. How can everybody reach you? And then I'll go over the evaluation process and how to save the slides.
Sure. You can go to just our website, kbrlegal.com, or you can email me directly. It's egannon, EGANNON @kbrlegal.com. And we're here to help.
Sounds wonderful. Great job. Thanks again. I know you've got a lot to do. I'll stay on.